Weapons possession. Do you know that the most common arrest for weapons possession in New York involves knives and guns? Prosecutors take weapon charges extremely seriously, and many firearm crimes are punished by a mandatory minimum prison term. Criminal possession of a weapon in the fourth degree is the only misdemeanor weapons crime in New York. It is commonly charged with per se weapons or any weapon with intent to use it unlawfully against another person. Per se weapons include firearms, stun guns, gravity knives, switchblades, blackjacks, knuckles, and kung fu stars, to name only a few. A controversial per se weapon is known as a gravity knife, which is opened and locked into place by flicking one's wrist because it is sold in many stores. The misdemeanor weapons possession crime also covers possession of any weapon with the intent to use it unlawfully against another. For example, a section of lead pipe or a frying pan, while not per se weapons, could be used unlawfully by hitting another person with them. This crime is often charged in association with others, like assault or menacing. As a Class A misdemeanor, criminal possession of a weapon in the fourth degree is punished by up to 1 year in jail. But based on a first or second arrest, it is possible to convince a prosecutor to offer an adjournment in contemplation of dismissal, known as an ACD, which is dismissed and sealed in 6 months, or disorderly conduct, which is a violation and not a crime and eventually seals. A prosecutor may also require a person to complete community service or stay out of trouble for a period of time. Criminal possession of a weapon in the third degree, which has nearly 12 provisions, is either a Class D felony or a violent felony, requiring a mandatory minimum prison sentence. One provision is a bump-up offense. If a person has a criminal conviction in New York or any other state and is charged with weapons possession in the fourth degree, then the misdemeanor becomes a felony, even for possession of a gravity knife. In addition, the third-degree crime is charged if a person possesses an explosive, a firearm silencer, 3 or more firearms, or a firearm that defaced to conceal its identity. In 2013, as part of weapons laws revisions, the mere possession of an unloaded firearm was increased from a misdemeanor to a felony called criminal possession of a firearm, which is a Class E felony. Possession of a loaded firearm is punished far more harshly. Criminal possession of a weapon in the second degree is commonly charged for a loaded firearm outside of one's home or place of business. The crime is punished by a Class C violent felony, which requires a mandatory minimum of 3.5 years in prison and a maximum of 15 years. The majority of weapons arrests follow a search of a person, car, or home. That means that police must have at least a degree of belief, called reasonable suspicion, that a person has or is about to commit a crime with a weapon. When searches are involved, a person who is charged with a crime is entitled to a hearing prior to trial to determine if the search was constitutional under the specific facts. If a judge finds that there was not at least reasonable suspicion or some exception to the warrant requirement, then it is possible that the weapon could be suppressed and the related charges dismissed. Whether evidence like a weapon is suppressed by a judge following a hearing depends on the specific facts of a situation. Virtually every weapons possession case is different. As a former prosecutor and current criminal defense attorney in New York, Andrew has handled hundreds of weapons cases. Visit the website of Andrew M. Stengel for more information. STENGELLAW.com or send an email to info@stengellaw.com.